Friends, I just pressed the Let's Go Live button, so let's wait for the stream to fire up all across the fruited plain of the internet. Before we go ahead and get started, it is a lovely Monday, and we got to wait for the tubes to connect themselves. We had a Facebook tube problem 2 seconds ago. It didn't connect. See, that's why we got to make sure the tubes work. So Facebook is not connected today. Don't know what that's about. We'll figure that out later. But are we working elsewhere? Looks like we are, so let's get started, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we are talking about Judge Chutkan and Donald Trump's latest motion filing for recusal to get her out of there for being a partisan judge. And we're going to go through it in detail. This one is fresh out of the oven today, and we always like fresh news right out of the gates. And so we're going to be going through it. It is not a long one. I've got the different filings pulled up. We'll go through the actual motion. Remember, this is the January 6th case, and this is the one that we're scheduled for trial in March of next year. Wow. So we were expecting a lot more substantive filings coming, and boom, we're here. And this is one of them. It is 9 pages. We'll go through it. We'll see what's inside. But what they're referencing are 2 exhibits from prior sentencings in front of Judge Chutkan's courtrooms. So remember, she was sentencing a lot of the J6ers. And Trump's defense team came out and they took 3 or 4 pages from each of these sentencings proceedings. Christine Priola and Robert Scott Palmer. And so we'll read through those and see exactly what the judge said, because she had some choice comments for Donald Trump. You know, Trump insurrection and you're ruining America. We're all going to die and you're going to prison, so on and so on. So we'll go through all of that and see what they have to say. Then there was another interesting filing over the weekend. Actually, on Friday, I think we learned that Mark Meadows, his attempt to remove his case from Big Fannie Willis's court, which is the court in Georgia, to remove it up to federal court, has been denied. And this was a big one. This is kind of a major loss for Meadows and a major loss presumably for Trump, who would have also enjoyed some of the benefits of being up in federal court. Now that's not going to happen, at least anytime soon. Mark Meadows has gone quick on this, has already filed a request for an appeal and a request for a stay. So he's appealing this up to the 11th Circuit, and he is asking the current court, the federal court, to stay the entry of the order. In other words, don't send it all the way back down to Big Fannie's courtroom. So we'll see that. The judge ordered a pretty seriously quick expedited briefing. So Big Fannie's got a, they're typing away over there, or somebody's typing away over there. And we'll see what they all have to say about it. Now, you may not have seen this today. I know it's 9/11, and we're tired of being under attack. I mean, we know we just had a January 6th attack. That was the worst thing since the Civil War. So January 6th was the worst thing since, well, even Pearl Harbor, 9/11. It wasn't, those don't even count. January 6th was horrible. I know, I was there. I was here with you, not there, but I was here. And we have another, unfortunately, insurrection that took place on the anniversary of 9/11. Another insurrection took place today. You can see by these AIDS protesters, HIV positive, I think, is she declaring that? HIV positive, they insurrected Kevin McCarthy's office today at the Capitol, which we know the last invasion of the Capitol was the worst thing since the Civil War. This is now the worst thing since that, I guess. So we're in big trouble. They were there fighting for AIDS. You can see them right in McCarthy's office, man. Insurrection. Screaming and shouting, interfering with the lawful operation of government, all the things. Little seditious conspirators, if you'll ask me. But we've seen this before. Remember this guy who was also in offices doing this? 4 years in prison. Well, they got arrested by the Capitol Police for insurrecting Kevin McCarthy today. We'll see this guy screaming and shouting, obstructing the entire proceedings in the congressional office building at the Capitol. Terribly sorry to bring this news to you. On the anniversary of 9/11, we've been attacked again. All right. Well, we'll see if they get the same consequences. Now, then we'll wrap up, my friends. Some good comments on that one. John McGarvey says, yuck, you're going to have to throw out the office on that one. Yeah, just throw the whole thing out. Just going to have to burn it down. Gross. All right. All right. Anyways, so in our final segment, we're going to have to go through. Man, it is a sad day as we remember. You know who else is sad? Joe Biden. He's very sad. It's true. The New York Times, man, they said that they're starting to face reality now, that Hunter is about to be indicted. We learned about that last week from the Department of Justice. They said, yeah, Judge, we were hoping you forget about this case, but you didn't. And so here's an update. We are going to indict him soon. And New York Times said that when Joe Biden learned about this, he got very sad and frustrated. Okay, that's their words, not mine. You know, and I don't like people being sad, man. I want everybody to be happy. But reality hits you hard, bro. And we learned a lot about reality from Big Fannie Willis. I'll never forget that quote, or the fact that she quoted herself in her own legal briefs. So we also have clips from Representative Dan Goldman, who says there's absolutely no evidence that exists against Joe Biden. He says, yeah, you know, some of these Hunter things might be problematic, but the reality is the Republicans are just making it up. And we've gone through a lot of evidence here. Hard to imagine that they need more, but they do. We also have a clip from Senator Coons. He's over from Delaware. He's a Democrat, and he's reacting to this. It's all, it's all old news that Hunter's about to be indicted. Byron Donalds is going to come out and take care of business on this one for us. And Byron Donalds is now using jump cuts, which is good news. We like to see the jump cuts in the edits. That means, man, they're getting hip and they're getting digital, which is always fun. So we'll go through all of that and more, my friends. And as you can see, we've got a lot to get to today. We had that last minute drop from Trump & Co., the recusal filing. But of course, it is 9/11, my friends, and of course, I think it's always appropriate to pause and just remember the people that we lost that day and the people who ran into the buildings to save other people, and we pray for them. This morning, we talked a lot about that and asked ourselves all sorts of questions about our government and about whether we trust them based on the fact that they continually lie to us and have continually lied to us repeatedly. So we asked ourselves a bunch of questions about that this morning on our members only stream at watchingthewatchers.locals.com. But I think we can separate that aside from the fact that we lost a lot of good brothers and sisters, mothers, fathers, daughters, sons, and so on. And so we pray for them and remember them, and we will not ever forget. We also had a good conversation about this, about some of the people who may have been behind it and responsible for it, or may have been, let's say, giddy about the aftermath of it and all of that stuff at watchingthewatchers.locals.com. We had a great conversation this morning. We really spent a lot of time on it. And we also talked about our new merch. Our merchandise is really coming along quite nicely. We're getting real soon ready to launch the new store at robertgovea.com. And we'll be super excited to share that with you. But we tried on the hats, looked at the shirts. We looked at a bunch of stuff today for our members. And robertgovea.com is where you can sign up for our newsletter and read all the daily reports on the show. But before we get into it, because we've got some heavy lifting to do, we got to make sure we're healthy and fortified. We're feeling well. We're looking good. One way we can do that is with our friends at fieldofgreens.com. I know that there are a lot of ads for the weight loss pills and fad diets, every other commercial and all that. We've all been there, we've all done that, and they don't work. But you know what does? Eating healthy, especially healthy servings of fruits and vegetables every day. You do that, and the weight would probably just start falling right off. But look, vegetables, I know, not a fan. And fruit, who's got time to prepare that every day? Sometimes it just goes bad. Sometimes you don't have time to eat it all. Field of Greens is a good solution because it is a science-backed formula. Specific fruits and vegetables that you're not going to find in any other product. Proper nutrition reboots your metabolism so you can burn calories faster and lose weight a healthier way. And Field of Greens is the only brand backed by a better health promise. Yes, you're going to look and feel healthier fast, but the greater proof is going to come at your next checkup when your doctor says, oh my goodness, you're looking fantastic. Whatever you're doing, keep it up. You're looking like you've lost some weight. Exquisite. So let's get you started. Fieldofgreens.com is where you can go. There's a bunch of other good stuff. If the greens is not your thing, there's a bunch of other stuff. And it tastes good. It I was going to say it looks good. It does. Look at the back of the label and you'll see there's all sorts of veggies there. Fieldofgreens.com, code Robert when you check out. Stay healthy, my friends. Important. But now we've got business to attend to. Donald Trump moves to recuse Judge Chutkan. Judge Chutkan, of course, presiding over the January 6th prosecution brought by special counsel Jack Smith. And this was a big one. We've all been waiting for this. We know that Judge Chutkan has been involved in sentencing other January 6ers. Two people named Christine Priola and Robert Scott Palmer, in fact, were sentenced in her courtroom. And during those sentencing proceedings, she had some commentary about Donald Trump. She might have had a thing or two to say about him. You know, my insurrection, my America's over, we're all going to die, blah, blah, blah. We've all heard it. But the point here is that Donald Trump's team is saying this means this judge is biased. She is no longer capable of being fair and impartial to a new set of facts that are in front of her because she's already made her opinion known in prior cases. And so these are two exhibits that Trump's team has actually submitted as attachments to the motion for recusal. Let's take a look at what Trump and his defense team submitted here. 9 pages submitted on 9/11/2023 in the United States District Court for D.C. This is Judge Chutkan's courtroom, so she's going to be getting this filing. And we know, as we've talked about here on this channel, when we've talked about this question, as it's come up many times, what can we do about this judge? Can we recuse this judge? Well, we've looked at the law, and it is a very high standard. It's not just something easy. In some other states and some other jurisdictions, like here in Arizona, for example, there's a much easier mechanism to get a different judge. You just file a notice for a change of judge. This is a much more robust standard because we're at the federal level. And let's see what their argument is. Donald Trump's lawyers writing, Your Honor, this is Donald Trump's motion for recusal of the district judge pursuant to U.S. law. They say President Trump hereby, through his lawyers, respectfully moves to recuse and disqualify the Honorable Tanya Chutkan pursuant to the law. Trump's defense says, and they're writing this to the court, so it's going to be to Judge Chutkan, really, and she's going to rule on it, says fairness and impartiality, Judge, are the central tenets of our criminal justice system. Both the defendant and the public are entitled to a full hearing on all relevant issues by a court that has not prejudged the guilt of the defendant and whose neutrality cannot reasonably be questioned. And so this is going into the court and they telling the court, Judge Chutkan has, in connection with other cases, suggested that President Trump should be prosecuted and imprisoned. Such statements made before this case began and without due process are inherently disqualifying. Although Judge Chutkan may genuinely intend to give President Trump a fair trial and may believe that she can do so, her public statements unavoidably taint these proceedings regardless of the outcome. Even if she is fair, the statement she's already made, it's already ruined because of her. The public will reasonably and understandably question whether Judge Chutkan arrived at all of her decisions in this matter impartially, we're already asking that, or in fulfillment of her prior negative statements about Trump. Under these circumstances, the law and the overwhelming public interest in the integrity of this historic proceeding require recusal. And we've seen this, okay? Judge Chutkan has already issued what I would say are insane rulings as we've read through them. One example of this is the discovery and trial date rulings that she has made. Trial is scheduled for next year, 2024, in March. And Trump's defense, according to the government's own numbers, have 12.5 million pages, give or take, of documents that they need to comb through. If you calculate that, that's 10 Washington monuments. It's a ton of material. The judge said you can read it quickly because the government prosecutor named Molly organized it nicely with sticky notes and highlighters. All right, it's insane. It's basically saying to the defense, you don't get to read the evidence. And so we're already asking questions about this. This case has barely even started. And it's almost like she wants it to be rigged against Trump because they can't even read the evidence. But they have some other disqualifying statements here. They say, hey, court, D.C. court. In October 2022, before the special counsel's appointment or the filing of this case, here's something that Judge Chutkan said. Before we even had an attorney appointed in October, Chutkan says, this was nothing less than an attempt to violently overthrow the government, the legally, lawfully, peacefully elected government by individuals who were mad that their guy lost. That's Trump. Chutkan says, I see the videotapes. I see the footage of the flags and the signs that people were carrying and the hats that they were wearing and the garb. And the people who mobbed the Capitol were there in fealty, in loyalty to one man, not to the Constitution, of which most of the people who come before me seem woefully ignorant, not to the ideals of this country, and not to the principles of democracy, she says. It's blind loyalty to one person who, by the way, remains free to this day. And I was thinking about this, you know who set him free today? This was back in 2022, right? So she's here complaining and moaning, oh, Trump, 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 he's still free. Nobody's done anything about this, blah, right? Who remains free to this day. Well, Trump showed up in her case on arraignment for this court, and she let him out on his own recognizance. He just didn't even, he's still out of custody. He's still free to this day, Judge. He's already come through your courtroom. He's still free. You could have locked him up. If this was really what you thought, okay, if you really thought that this was nothing less than an attempt to violently overthrow the government, led literally, done in fealty to one man, it's blind loyalty to one person. They were there in fealty, in loyalty to one man, all right? In other words, they were there, he caused it, and she let him walk out of the courtroom. Amazing. That's weird. Why did she let an insurrection, violent overthrower of the government out? It's because this is all just nonsense. Now, we'll come back to this. This is the excerpt. They say, court, the public meaning of this statement is inescapable. President Trump is free, but should not be. It's an apparent prejudgment of guilt, obviously. These comments are disqualifying standing alone. However, this was not the first time that Judge Chutkan expressed such an opinion. Before that, in December 2021, she similarly stated the following thing. She suggested, in her view, this is Trump's lawyer saying, that Trump was responsible for January 6 and should be prosecuted. Here's what the judge said. He went to the Capitol because despite election results, which were clear-cut, despite the fact that multiple court challenges all over the country had rejected every single one of the challenges, Mr. Palmer didn't like the result, the man who's been charged and sentenced here. He didn't like the result, and he didn't want the transition of power to take place because his guy lost. And it's true, Mr. Palmer, this is the judge scolding him. You have made a very good point, one that's been made before. Take the people who exhorted you and encouraged you and rallied you to go and take action and to fight, that they have not been charged. Oh, like who? Like Trump? That is not this court's position. I don't charge anybody. I don't negotiate plea offers. I don't make charging decisions. I sentence people who have pleaded guilty or have been convicted. And the reason why the judges are not supposed to make charges, because if you're judge, jury, and executioner, that's kind of like an insane system, unless you're Hollywood. The issue, she says, I sentence people who have pleaded guilty or have been convicted. The issue of who has or who has not been charged is not before me. I don't have any influence on that. I have my opinions, which she's communicated, but they are not relevant. So she's saying to this gentleman, so you have a point that the people who may be the people who planned this and funded it and encouraged it haven't been charged, but that's not a reason for you to get a lower sentence. So in making these statements, Trump's lawyers say the following. Chutkan agreed with portions of his sentencing memo, the defendants, which similarly and wrongly placed the blame on President Trump, and both complained that he had not been charged. The defense lawyer for Palmer said, quote, those voices, including the voice of the then president himself, had convinced persons like Mr. Palmer that the election was fraudulent and that they must take action to stop the transition. So they're all pointing their fingers to Trump, which I think is a perfectly fine defense strategy. While many of the people who participated in the Capitol riot will be going to prison, the architects of that event will likely never be charged. They say, although Judge Chutkan correctly noted that she doesn't have any influence on the charging decision, she did say, you made a very good point, that the people encouraged you have not been charged. And this is a reflection on her apparent opinion, right? So they're really parsing her words, saying if you break that little sentence down, what she means is Trump's conduct, 1, occurred, and 2, that she supports the charges. Otherwise, she wouldn't have characterized his point as being very good. She said, very good point there. Why hasn't he been charged? Similarly, she said, I have my opinions, suggests in her view that almost 2 years before the initiation of this matter, President Trump should be charged. So, they continue, Your Honor, with all of your prior statements here before you in your D.C. court, public statements of this sort create a perception of prejudgment incompatible with our justice system. In a case this widely watched of such monumental significance, the public must have the utmost confidence that the court will administer justice neutrally and dispassionately. Judge Chutkan's pre-case statements undermine that confidence and require disqualification. Now, here's the law. And let's spend a minute on this. They say unbiased, impartial adjudicators are the cornerstone of our system. Any judge shall disqualify himself when their impartiality might reasonably be questioned, right? And this is the standard here. This is a high standard, reasonably be questioned, and impartiality. And now the judge is going to say, I'm not, there's no basis for questioning me. A judge should respect and comply with the law and should act at all times in a manner that promotes public confidence. Now, we're asking ourselves, right, who decides whether a judge is impartial or whether it is reasonable or whether her impartiality can reasonably be questioned? What they're giving us here is an objective standard. Rather than asking her, hey, judge, are you biased? And she says, no, I'm not. We're not really concerned about her personal opinion or Trump's personal opinion or anybody's subjective opinion. We're zooming out on this and saying, what would a reasonable observer, any third party, say about this? Like swap the defendants out. Like if that was your kid in there instead of Trump, would you still be okay with that? If that was Barack Obama in there instead of Donald Trump, are you still cool with Trump's DOJ prosecuting everybody? Right, we're asking ourselves, like, objectively standing out, what would somebody say? Under settled law, what matters is not the reality of bias or the prejudice, but its appearance. That's a Supreme Court case. Therefore, all that must be demonstrated to compel recusal is just the showing of an appearance of bias. That's it. Sufficient enough to permit an average citizen reasonably to question a judge's impartiality. So it sounds like a pretty low standard. This inquiry is an objective one, made from the perspective of a reasonable observer who's outside the case. In other words, it's of no consequence that the judge is not actually biased, right? It doesn't matter that she's not actually biased. It just is whether it appears. Fifth Circuit stated, the overriding concern with appearances stems from the need to have an unimpeachable judicial system with unwavering confidence. They've wrecked that. Therefore, to preserve the reality and the appearance of impartiality, a judge should recuse herself when her impartiality might be reasonably questioned. Obviously, she's not done that. They go into argument. They say the following. Here, to the D.C. court, there is little doubt that reasonable members of the public might, in viewing Judge Chutkan's statements, believe that she has prejudged both the facts pertinent to this case and Trump's culpability. Her statement, when she said it's blind loyalty to one person who remains free, they say straightforwardly, and of course incorrectly in the defense's view, suggests that Trump is culpable for January 6th and that he should not be free. That's how I read it. This would be a natural interpretation of her comments in any context, but it's particularly poignant here, where Chutkan directed her statements to a defendant she was about to sentence to an extended term of incarceration. Her comments suggest that she had reached a conclusion before this case that Trump is more deserving of a term of imprisonment than the defendant she was sentencing. She brought up Trump in Palmer's sentencing. Likewise, most reasonable observers would understand Judge Chutkan's statements that it is true, Mr. Palmer. She said, you made a very good point, one that's been made before, but I have my opinions. She did say that Trump exhorted, encouraged, rallied others, and it's a suggestion that Trump should be prosecuted. So they quote some case law, 10th Circuit. They say courts have found an impermissible level of bias when a judge's remarks or actions reveal that she has prejudged the guilt of a defendant. Sounds like she has. She's seen enough evidence here from other January 6 cases. Trump's defense says Chutkan made her comments from the bench during court proceedings, which only amplifies the concern of prejudgment. She didn't do it to media. She didn't do it outside the courtroom. It was in the courtroom on the record to a defendant. President Trump was not a party to those cases. He has got no ability to object or persuade the judge, and she just made him. They say the indictment here does not even allege Trump personally entered the Capitol or incited violence. It makes numerous allegations that he made false claims. While Trump denies these, Judge Chutkan's comments can reasonably be understood to mean she's already formed an opinion about his guilt and many of the allegations in this case, obviously. Moreover, because the statements were made on the record in support of incarceration sentences, the public must reasonably understand her statements to be the product of considerable thought, right? She's not just riffing off the cuff here, ranting at a party or something, caught off mic. No, she's sentencing somebody on the record. There's a court reporter writing it all down, saying that this is reflective of her core views. Unlikely those things are changing. And here, as President Trump's supposed culpability was not an issue for her, she wasn't talking about Trump or making decisions in those other sentencings. They can say that she got her views about Trump from extrajudicial sources, right? Those cases, Trump was not on trial in front of her. He is now, but he wasn't back then. So why was she commenting about his criminality when she had not seen any evidence about it at all? Unless she had already come to her own conclusion and connected Trump to these defendants. Trump's people say every judge must uphold her oath of office. That is, to faithfully and impartially discharge and perform all duties incumbent upon the Constitution and the United States. So help me God, that's the code. The foundation of that oath is a judicial branch designed by our founders to be entirely impartial and avoiding even the perception of prejudgment. And I can't, I harp on this a lot about how the legitimacy of the institution is a real catastrophe for this country. And I can't even articulate how important it is. When people stop believing the system is impartial or they have faith that it is legitimate, it feels partisan, the whole system stops working. Like that is necessary for it to work. And we talked all about this in the founding papers of this country, which is why legitimacy is so important. And they're just throwing it right in the garbage. Our system guarantees that the government prove a defendant guilty in front of a jury of his peers as part of a trial without any suggestion of partiality on the part of the presiding judge. Only when all three prongs are present and beyond dispute does our system function as intended. It's right. If you don't have it, it's like you might as well just not have a heart or a brain. It just doesn't work. But both by its procedure and its content, this trial is a test of the very foundations upon which our government is built. There is an overwhelming public interest in ensuring the perceived fairness of these proceedings. In a highly charged political season, naturally all Americans, and in fact the entire world, are observing these proceedings closely. Only if this trial is administered by a judge who appears entirely impartial could the public ever accept the outcome as justice. The law commands a judge to recuse herself if her impartiality might reasonably be questioned. The standard is not particularly high, especially in a case, as here, where the DOJ answers to a president who is prosecuting his main leading opponent in an election that will take place in just over a year. Now, they say the standard is low. Now, legally, you might say so, but as a practical matter, judges don't get recused regularly. Now is not the time for the American people to second guess a judge's impartiality, even though I agree completely that she should be recused. Rather, the court should ensure the public remains unwaveringly confident in its decisions and its commitment to the fair and impartial administration of justice. Therefore, President Trump requests Judge Chutkan recuse herself from further proceedings. For the foregoing reasons, Judge Chutkan should recuse herself and ask and direct this clerk to randomly assign this matter to another district judge. So, judge, recuse yourself, and then clerk, give it to someone else. Additionally, given the overriding public interest in ensuring the appearance of fairness in this proceeding, President Trump requests the court consider this motion on an expedited basis and, pending resolution, withhold rulings on any other pending motions. So don't work on anything else that you're working on. And what I want to do here is take a quick look at what the DOJ is going to do on this. And I was searching for the manual. To see if they have some details on how they'll respond to this. Yes. All right, so this is from the DOJ manual, and let's just pull this open while we're here and see if they give us any insight as to what they're going to do in response. They say, okay, Section 455 deals with the disqualification of the district court judges and states in part, shall disqualify him or herself when their impartiality might be questioned. They reference us to a CFR, which is the Code of Federal Regulations, which establishes procedures. Now, this is what the DOJ has to do. So the Code of Federal Regulations establishes procedures by all government lawyers, aka prosecutors, prior to filing a motion to recuse. They got to get permission. Okay, so this is if they file it, but I'm not seeing anything if the other side files it. All right, so we'll see. We'll see what the DOJ comes back with. Now, you'll see here that there were two sentencings that were also brought up. We read a little bit of the highlights of them in the actual filing, but let's just take a quick look at what they included. We have here 8 pages, and this is the case, Donald Trump being prosecuted in Judge Chutkan's courtroom, District of Columbia. We see this is Exhibit A, and this is just an excerpt from the sentencing in Judge Tanya Chutkan's court. So this was some time ago. This is exactly what they were referencing in their filing. And this is the final sentence from Miss Priola. She says, something, to love one another, and despite our differences, she's telling the judge, Your Honor, I just want to be a good example in the world of how to help families not be divided, and coworkers and friends not be divided, and our nation not be divided. I just really want to try to do that. And whatever sentence you give me, I hope it just brings justice and peace, some peace to the people that I've hurt. Thank you, Your Honor. And she says, thank you, Miss Priola, the judge. After calculating the sentencing guidelines and the departures and hearing the statements, I now have the difficult job, as I ever do. I have to impose sentence. The government has stated these purposes, and I don't need to list them all again. We're familiar with January 6th, says Judge Chutkan. We've had close to 900 prosecutions, all brought in this court. This is a small court. All judges are taking their fair share of these cases, myself included. What does this have to do with anything? And every case presents a different defendant in a different situation, and I know my other colleagues endeavor to treat each person as an individual and not part of a mob. And we have to be mindful of what happened that day. Okay, so she's talking about how busy they are, right? We're real busy, tired of seeing you people. I'm supposed to treat you as an individual, but we have to be mindful of what happened. You were a part of a mob. Every single time that I see a videotape of what happened that day, I'm struck anew with both the horror of what was going on that day and how close we came to not fulfilling one of the basic functions of our democracy, which is the peaceful transfer of power, which we lecture other governments all over the world on, which now she's literally part of the prosecution that is prosecuting a political opponent of the guy in power who's her party. We should be lecturing ourselves. We are lecturing. We're lecturing you, Judge Chutkan, for being a part of the problem, for being a part of the evaporation of the democratic ideals. We're supposed to be an example of not prosecuting our political opponents in America. But you're not going to sentence yourself, are you? And so while Mr. Langmark, they say, this is Judge Chutkan, is correct that your background didn't involve any criminal activity, Priola, the events of that day and the seriousness of those events cannot be understated. This was nothing less than an attempt to violently overthrow the government and the legally, lawfully, peacefully elected government by individuals who were mad that their guy lost, right? I see the videotapes. I see the footage, blah, blah, blah. We already read all that. There is no mob without members of the mob, and Trump remains free to this day. He should be incarcerated if she had her way. If she was prosecuting this, he would have been rounded up. So Mr. Langmark made a point in his sentencing recommendation. If we were to take your participation out of that group, everything would have still happened, but you were there. And the people in ways, they act in different ways when they're with a mob. And so the seriousness of the offense and blah, blah, blah. And you're one of a few defendants, Miss Priola, to at least acknowledge the harm. But you and other rioters are calling themselves patriots. Oh man, that makes her, I think, skin crawl, probably. Nothing could be further from the truth. The people who stormed the Capitol that day were what? Federal agents, Ray Epps, transcripts cut off. Ray Epps, FBI agents, pipe bombers that never got found. FBI's most wanted list, like Ray Epps, who, never got charged with any crime despite being on the FBI's most wanted. So very dramatic, okay, very theatrical. And the same thing is happening in the other type of sentencing, where she says much the same thing in the case of Robert Scott Palmer. Here's the transcript from her, right? This was the other thing they referenced. I've reviewed the government's opposition, and now I'm going to deny the motion for a more lenient sentence. I'll go into this further. It's difficult because you've got prior convictions, and it's the same type of thing, right? This is where she was saying that Trump is also the fact that other people exhorted you. You were free to leave. You didn't leave. And I have my opinions. The issue of who has or has not been charged is not before me. And I've got my opinions, like Trump should be death penalty. But you don't get a lower sentence for that, right? So this is Judge Chutkan, obviously very biased, very partisan. And that is just her prior statements. They didn't go into anything in this case that we've covered thus far, which of course includes a lot of other problems, like the fact that she said it was reasonable for the defense to read millions, literally millions of pages of documents before trial starts, which is going to be happening in March. So lunacy. Donald Trump files a motion for recusal. Government's going to respond. And if I have my guess on it, Judge Chutkan's not going to recuse herself, which means we'll be seeing more of her. And we'll continue to cover, my friends. Thank you for joining us as we do. Thank you for liking this video and subscribing wherever it is you're watching it. And we'll look forward to seeing you when we're back here on the next one. All right. Now, we've got a little bit more heavy lifting to do because we're just getting warmed up over here. And we've got now Mark Meadows, who is getting some bad news. He was over the weekend and was looking for a different ruling. But of course, that did not happen. And so let's get this queued up and ready to go with Mark Meadows. Mark Meadows, bad news, had his attempt to remove his case to federal court denied. He's being prosecuted in Big Fanny's courtroom right now. Doesn't like that. Knows that he was Donald Trump's chief of staff. Says he's got some federal protections as a result of that. One portion of the way our law works is that when you're in the federal government, you're not supposed to be under attack by partisan hack prosecutors from the state level just filing charges after you so that you can do your job as a federal official. You're a federal official. You've got federal supremacy, kind of the whole reason this law exists. But Mark Meadows asked for a removal to take it from state level court to federal court. The judge denied it. Now, Mark's team unhappy about this. They've asked for a stay, meaning, judge, while we appeal this case, please don't do anything. Just let us appeal it. And then subsequently, they filed an immediate appeal. Now, I want to spend some time going through the documents, but not as much time on the judge's original ruling, because the ruling is going to be responded to in Mark Meadows' request for a stay. He's going to say, Judge, this is why I think you're wrong. And he's going to hit the highlights about what was wrong from the order. So it doesn't make sense to read both of them in depth. We'll just hit the highlights from the judge's order so we can get our bearings straight on exactly what happened here. This is what the judge said, and it's a bit of a longer filing. 49 pages out of the Northern District of Georgia. And this is bad news, not just for Meadows, but it's bad news for Trump, because I think that if this case was removed for Meadows, Trump would have just been, okay, perfect, let's go. I'm removing too, and here we go. I'll just join you right up there. Thanks for opening the door and holding it for me. But I don't think that's going to happen now, because when Mark Meadows was even filing this in the first place, he had to go through a formal hearing. He had to testify, and all of that gave Fannie's office an opportunity for cross-examination that Trump is not going to want to endeavor this early in the case. So they were kind of putting all their eggs in the Mark Meadows gets accepted into federal court hat. Now that's not looking good. Now, this is something that is immediately appealable, and we'll go into that in a minute. But here's what the judge said. We'll hit the highlights. Notice of removal. He says, the matter appearing before me asks the question, has Mark Meadows carried his burden of demonstrating that removing from state court is proper under the law? The judge says, well, having considered the arguments and the evidence, the court concludes that Meadows has not met his burden, and therefore the court declines to assume jurisdiction over the state's criminal prosecution and, remands the case back down to Fulton County, Big Fannie's courtroom. And this is a little bit of a surprise. And now we're asking ourselves, how did this all happen? Well, let's see what we can tease out of here. Background: Mark Meadows was the chief of staff. We know that. Grand jury came back, charged a bunch of people with indictments. Meadows got charged with RICO charges and conspiracy. The court declined to summarily remand the case, and we're fast forwarding through a lot of this. They tell us about what happened at the hearing. They also give us the legal standard. They say a federal district court should be slow to act where its powers interfere with state levels. An exception to those general concepts is a special rule is when a federal officer is part of the removal statute. It allows, literally, a criminal prosecution against a federal officer to be removed. That's why they filed it here. It's an incident of federal supremacy, and it's designed to give federal officials a federal forum so they can raise federal defenses. Now, to fast forward through a lot of this, essentially what the judge is saying is that Mark Meadows is not a federal officer within the definition of what it would require to enable him to have a federal defense as a federal official. So, in other words, Mark Meadows was doing some stuff for President Trump as a chief of staff, and he was doing stuff for election candidate Trump as an election candidate official. Some stuff was official. Some other stuff was not really official. Anything within the chief of staff obligations was protected. Anything outside of the chief of staff, which would include things like, I would argue, election stuff, they say, no, it's outside of chief of staff. It's campaign candidate Trump stuff. And therefore, it is not related to Meadows' color of office. That's how they're going to bifurcate these two things. They're going to separate them out. And so let's fast forward through a lot of this, because I think we can hit the highlights in some of the conclusions. You can see it's a big, long opinion. He's really splicing through a lot of this. Yeah, Meadows asserts that another function of Meadows' role as the chief of staff was to be generally aware of what's going on. He had to prioritize the president's time. He said, though, he was bound by the Hatch Act and couldn't engage in political activity. So political activity is outside the scope. And so this is the court. The court finds that the color of the office of the White House chief of staff did not include working with or working for the Trump campaign, except for simply coordinating his schedule, traveling with the president to his campaign events, and redirecting communications to the campaign. Thus, consistent with his testimony and the federal statutes and regulations, engaging in political activities is outside of the White House chief of staff duties, which means it doesn't count. Right? So it doesn't have a federal defense for all of those activities. Now, Mark Meadows obviously says, this is insane, this is ridiculous. He says, nuts. Okay, we're appealing this, filed this immediately, right after the ruling came out, dropped this one, notice of an appeal. He said, notice is hereby given that Mark Meadows appeals to the U.S. Court of Appeals for the 11th Circuit, issued by Judge Steve C. Jones. Now, this is another filing. So in addition to that, which they're filing their appeal to the circuit court, they're also submitting this back to the original judge, right? Now, they're going to say, Judge, look, you're very wrong about what you just did, respectfully. And so we're going to ask you for a stay. In other words, don't send this case, don't remand this back down to Fannie's court until the appeal is finished. So they say, Your Honor, we just got your ruling. We hate it. Thanks, by the way, ruling our Friday. And so we're now asking the court to stay the effect of its order. Don't put it into effect. Put it on hold. You currently declined jurisdiction of this case, and you remanded this back down to Big Fannie's court. But we're appealing this to the 11th Circuit. And they say Mr. Meadows is seeking expedited review later. He's got a right to appeal. And it's important that you stay this case to stop it from this case becoming a shuttlecock. Don't let this case become a shuttlecock. Just like in the game of badminton, when you just ping pong the shuttlecock back and forth. All day. Federal court, state court, federal court, state court. That's a First Circuit opinion quote, 2021. So they say, Your Honor, look, while Mr. Meadows respectfully believes that you, Judge, erred on this matter, this court need not agree to stay the remand order. The court may stay its order if Meadows has a substantial case on the merits and other factors like irreparable harm, balance of the equities, and public interest favor a stay. Here's why you should. The court should issue a stay to prevent the irreparable loss of rights that Meadows asserts under the federal removal statute and under the supremacy clause. So, Judge, if you do not stop this, Fannie is just going to run over us. I mean, she's literally going to roll over us, crushing the case. And Mark Meadows writes, they say, first, here's a couple other additional reasons. Judge, this is why you were wrong. Number one, Mr. Meadows has at least a substantial case on the merits, all right? The court's own order, you said it yourself, Judge, that this case presents a novel question, which informed your own decision. You also relied on the state's novel theory of prosecution to distinguish numerous well-established precedents that favor removal for federal officers. So you recognize this is a new case. You then took the government's new theory and you just incorporated that. But the Court of Appeal is going to review those issues de novo, which means they're going to take a fresh look at it. They're not going to say, sometimes when you go to the Court of Appeals, they can only look at certain things, right? They can't look at the entire case. People will think, well, I want to appeal my case. That doesn't mean you get a second trial. It just means it's like a do-over. It just means that one portion of the evidence or testimony or whatever the problem was gets reviewed. And so sometimes that will happen, but sometimes they'll say, was there clear error? Was this an abuse of discretion that justified changing it? Other times they'll say, this is brand new. So they just took a crack at it at the lower level court. Let's see how they did. And if it's a brand new issue, they'll review it de novo, which means on their own, of new. There are several aspects of the court's remand order that depart from the ordinary removal precedent, and therefore Mr. Meadows at least has a substantial case on the merits before the 11th Circuit. Also, Judge, you were wrong when you failed to credit Mr. Meadows' account of his conduct and his duties. Said the Supreme Court has held that federal courts must credit the removing party's theory when determining whether he acted under the color of federal office. So in other words, Judge, you're supposed to take Mark Meadows' word for it. You didn't. You're supposed to. You're not supposed to just intersperse your own judgment into his thinking. You can't read his mind. In the remand order, the court departed from that rule and credited the state's allegations over Meadows' testimony, or they discounted Meadows' testimony. In the order, you credit the state's allegations that Meadows requested a memo on disrupting or delaying the joint session of Congress and that he attended a meeting about fraud in Michigan. They also say that he's inverting the standard for removal. All right, so the judge is basically reversing what sides need to prove what. Both the statutory text, they say, Judge, and the binding 11th Circuit precedent make clear that if any portion of the prosecution is removable, the entire case is removable. That's the law. But in your order, this court effectively held the opposite, that the case should be remanded if there is any way the state could prove its case without relying on an official act. So in other words, she gave Fannie more deference rather than the federal official more deference. Think about an analog like in criminal law. Criminal law, we say the government has to prove the defendant guilty beyond a reasonable doubt. Well, that's our standard, but what about if we just said, in this case, though, the defendant has to prove his innocence beyond a reasonable doubt? And what? That's weird. It's a burden shift. You're asking the other side to do something else. And the judge said, in sum, to establish a RICO conspiracy, the state only need to prove that any co-conspirator committed one overt act in furtherance of a conspiracy. Whether the conspiracy was even charged in the indictment or not. In other words, the state can prove its RICO charge against Meadows by showing any one of his co-defendants committed any overt act in furtherance of the conspiracy, whether it's even in the indictment or not, which is kind of an insane standard. So, Meadows was a part of the conspiracy regardless of the overt acts. He's on the team whether the overt acts applied to him or not. Raising the burden. So now they're shifting the burden over to Mark. They say the threshold for removal is quite low. We've already seen that. But in the remand order, this court held Meadows to a higher standard. They effectively are requiring him to prove his defense and to justify the full scope of his duties in order to obtain the removal. There is a substantial possibility that the 11th Circuit will disagree on at least one of these issues that Meadows will raise on appeal. Therefore, we need a stay. Number 2, absent any stay, there's going to be a substantial risk that Meadows will be irreparably injured. Federal rights he invokes include freedom, but also burdens from a state court, the burdens of a state court defense. The irreparable harm has already begun. He was compelled to self-surrender on August 24th after Big Fannie refused a modest delay of his arrest. Meadows has been compelled to waive arraignment, post bond, begin preparing for a defense for a state prosecution for which he doesn't even think is legitimate. Meadows has sought to minimize his harm. He's asking the state to sever and stay his case. But to this date, the state court held a hearing but has not rejected the state's aggressive timeline. So, at a minimum, Your Honor, the court should stay the remand to protect Meadows from a conviction while he is appealing this. Absent a stay, the state will continue seeking to try Meadows 42 days from now on October 23rd. If the state gets its way, Meadows could be forced to go to trial, could be convicted, could be incarcerated before the standard timeline for a federal appeal would even play out. So Meadows' rights would be nullified. And third, if you just put a stay on this, it doesn't hurt anything. It's not going to prejudice the state or the other defendants. It's not going to prevent other proceedings. And so, granted. And lastly, a stay is in the public interest. The very premise of the Supremacy Clause and the immunity associated with it, along with the federal removal statute, is vital to a functioning country. If a state can proceed to trial and impose a verdict, it's going to give a very chilling effect to every federal law that goes out. And we don't want this case to become a shuttlecock, batted back and forth between both parties, the state courts and the federal courts. Therefore, the court should stay the remand pending appeal submitted by John S. Moran for Mark Meadows, Trump's former chief of staff, and submitted on the 11th day of September. And so you can see this was the two filings. The court came out, asked for very expedited briefings on this, and here is what they said. They say, all right, let's go fast. This matter appears before the court. Mark Meadows filed his emergency motion. And now Fannie needs to respond by 12 p.m. September 12th, 2023. Signed by the judge, Honorable Steve C. Jones, U.S. District Judge. So this is a big, big speed bump in the road for Mark Meadows and for the removal process, because now they're asking for just a hold. And if the judge says no, well, the appeal is going to take forever to go through. And Fannie can just steamroll ahead with her prosecution. And so things getting a little bit dicey out there. We're going to see what happens next. The government is going to respond, and we'll continue to cover, my friends. Thank you for subscribing and liking this video wherever it is you're watching this. We'll see you on the next one. All right. Now, my friends, we have another horrific day in America that we have to talk about. Put the kids to bed. All right. It's about to get insurrectionary, seditious in here. Another insurrection in America, my friends. Sorry to break this news here with you today, but the left took over Kevin McCarthy's Capitol office. And as we know, the last time this happened, it was the worst attack on this country since the Civil War. We're going through it again. Now they're fighting back against McCarthy's attack on AIDS. So these people literally were in the Capitol building, the same one that this guy was in, or the same offices that this guy was in Pelosi's office. He was in McCarthy's office. She was Speaker of the House, and now he is Speaker of the House, and both have had their offices insurrected. So the question is, he got 4 years in prison. Are they going to get 4 years in prison? Let's see who these people are before we watch some of the video footage. You can see this person. I don't want to misgender, so they're very upset about this. But this is the story, the background on exactly what happened there. It says HIV protestors occupy Kevin McCarthy's office. Now, 7 of them were actually arrested. Nobody was shot, though. And activists, they get on their knees and chant. They said, McCarthy, pass PEPFAR now. Pass PEPFAR now. The money for the global AIDS program ends on September 30th, unless it's reauthorized. And the program is caught up in an abortion rights fight. So these protesters, they stormed Capitol Hill on Monday. U.S. Capitol Police removed them from McCarthy's office in the Rayburn House office building, which is across the street from his office. Rayburn House office building, which is across the street from the official speaker's office in the Capitol building. So I don't know if it was the same exact building or the same exact office, but the point is, insurrection regardless. The 7 protesters, some wearing t-shirts that read HIV positive and waving signs calling to end AIDS, were handcuffed and taken away. It's unlikely that McCarthy was in that office. He usually works out of the Capitol building, but his staff didn't immediately respond to the inquiry. Monday marks the day that they're returning to Washington after the summer break. And it's also the day of 9/11. I mean, hello. I mean, this is what we're talking about here. I mean, this is a horrific attack on our country. And for some reason, these images aren't loading the way I'd like them to. But this is what the story says. PEPFAR, a widely praised global program started by George Bush, has become caught up in a fight over the abortion. Reauthorization deadline coming up September 30th. It's known as the President's Emergency Plan for AIDS Relief, fights AIDS and the HIV and the virus that causes it in areas around the developing world. They're credited with saving 25 million lives. And the activists, they're from this organization called Health Gap Global Access Project, which is a nonprofit that advocates for those with HIV and Housing Works, a group dedicated to ending homelessness. They say it saved 25 million lives, but some say the money, the program is nearly $7 billion. Some people say it goes to abortion advocates, and so they're unhappy about that. President Biden's administration, the program leaders, they deny this. They say it doesn't go to abortioners. However, Republicans who head the subcommittee is leading the charge to stop the program's renewal until anti-abortion restrictions are lifted. McCarthy's already dealing with a full plate. And so let's see what it looked like when this insurrection happened here in America. And I know you're going to hear some what these people sound like, but we got to listen to it. This is The worst attack since the Civil War again. All right, so I mean, I'm pretty much in shock right now. Is our country even working anymore? Is it still functional? Is Congress come to a screeching halt? I might have to ban myself because I'm, watching insurrectionists again and I'm feeling insurrectionary, so banning misinformation. It's a very complicated situation. I don't know what's happening right now, actually. So this is another insurrection in the Capitol office. And those people were in there interfering with the lawful operation of the government. As far as I can tell, there were other workers there. Now, this guy, Richard Barnett, who put his feet on Nancy Pelosi's desk, he got 4 years in prison. Right? We've already seen this story before. Arkansas man propped his feet up on the desk, more than 4 years in prison. He was in a Capitol office at the Capitol. All the folks said that this cannot be repeated without serious repercussions. This is what the judge wrote. Here's your judge. U.S. District Judge Christopher Cooper. He said, you seem to enjoy your notoriety there, Richard. All the folks who follow BIGO need to know that the actions of January 6th, this is the judge, cannot be repeated without some serious repercussions. Unless you're an HIV activist or something. Alluding to the media attention that he got. 54-month sentence for a retired firefighter from Gravette, Arkansas. He was convicted at trial on 8 counts, felony charges. Look, felony charges of civil disorder and obstruction of an official proceeding. Well, maybe it wasn't an official proceeding in McCarthy's office, but it was certainly civil disorder, wasn't it? The photos of Barnett lounging at the desk made him one of the most memorable. The judge said joining the riot, he told the judge that it was a mystery why he joined the riot and so on. But it's going to be very curious to see, now that we've been attacked again, if there will be any repercussions. The Capitol Police did conduct the arrests. Here is the scene on what it looks like. And again, make sure your kids are in the other room. Insurrection! Insurrectionist! Insurrection! Well, are they going into the gulags? Get that woman. I don't see anybody getting shot in the face with pepper spray. Why are they not shooting anybody in the face with pepper spray? Like they did on January 6th. That's all I'm asking. All right, arrest them faster, okay? Arrest them faster. All right, so they're getting all searched up. Here, let me just turn that down a little bit. Okay, so they bring this dude out. Insurrectionist, this guy.
Pass Bedford now. Pass Bedford now.
All right. I mean, this is this is a security breach. They're patting her down. Who knows what she had there? Yeah. All right. Oh yeah. Sorry, I missed. I used the gender. That's a good question. I don't know. Look at these insurrectionists. This attack on American democracy. All right, my friends. Well, there we go. Another attack. I can't wait to hear Kamala Harris come out and scream at all of us. This woman here looks about as entertained as the rest of everybody. Who are these idiots? I just try to go get a coffee, for crying out loud. All right, well, that's another insurrection. So we'll see what happens to them. They'll probably get medals or something for insurrecting Kevin McCarthy's office. Kevin McCarthy's office, it's just kind of like a quick arrest. We'll see if they get charged with insurrecting America. I mean, looks like, my friends, we barely survived another one. Barely survived another one in America. All right, thanks for subscribing wherever you're watching this. All right, and let's carry on our last segment on the day and see what is up with Joe Biden. Are they going to the gulags? Are they taking them right to the gulags? I wonder if we're going to have two sets of gulags now. All right, let's see. Joe Biden is very sad. That's according to the New York Times. He's learned finally that Hunter is about to get indicted. He had no idea that there was any criminality going on for the last, 20 years. But now that we know that indictment is coming, we see Joe Biden is frustrated and just feeling a little bit emotional. Here's what the New York Times says. President Biden keeps Hunter close despite the political peril. And look at that, father, son, it's just a beautiful relationship they've got. But earlier this summer, Joe Biden was feeling hopeful. Country's doing terribly, but he's still feeling good. His son Hunter's lawyers had struck a plea deal with federal prosecutors, his federal prosecutors, on tax and gun charges. And it seemed to the president that the long legal ordeal would finally be over. But when the corrupt agreement collapsed in late July, Mr. Biden, whose upbeat public image often belies a more mercurial temperament, was stunned. Wait a minute, what? My rigged DOJ couldn't get my crackhead son through the system? Guess what happened to Joe? He plunged into sadness and frustration. Oh, man. Pour one out for Joe. He's sad. This is according to several people close to him who spoke on condition of anonymity to preserve their relationships with the Biden family. Since then, his tone in conversations about Hunter have been tinged with resignation that was not there before. It's like, oh, hey, Joe, all those questions that everybody was asking you about during 2020 and the years before that about Burisma, and you kept lying to all of us? No, he's great. He's like selling a lemonade stand over there or something. No, it's all true. You knew it was true. You just didn't want to address it. Now you're sad about it? Okay, nobody cares. Now the Justice Department plans to indict Hunter on a gun charge, which is like a joke of a charge relative to the other charges. White House advisors are preparing for many more months of Republican attacks and the prospect of a criminal trial in the middle of the presidential campaign. Yeah, like Trump's 4 of them, right, that they're trying to jockey. Republicans have cast Hunter's troubles as a stew of nepotism and corruption, which the Biden administration denies. But there is no doubt that Hunter's case is a drain, they say. New York Times. The saga reflects painful dynamics of the first family, shaped by intense ambition, deep loss with anger and guilt. It's the story of two very different, if much loved sons, and of a father holding tight to the one still with him. Oh my gosh! Who wrote this terrible article? Katie. Oh gosh. This account is based on interviews with more than a dozen people close to the Biden family who declined to speak on the record. It's a puff piece, this stupid piece. People who know both men say their bond is singular in its intensity. But even allies of Biden, who prides himself on his instincts, say at times he's been too deferential to his younger son, often appearing unwilling to tell him no, despite his problems. Oh, gosh. So this is just, it's a puff piece, man. It's like why we should feel sad for Hunter and Joe and Bo. And Joe lost one of his sons, and now it's his only son, and that's why he can't say no. He's too deferential to his $83,000 a month check out of Burisma, $1 million a year. Give me a break. This is shameful. And she's reporting from Malibu. All right, so she's hanging out with Hunter. Oh, she's hanging out with Hunter and everybody, reporting from Malibu, California, and Washington. All right, get a real job. All right, anyways, the point is that's what they're saying. Now, they're in panic mode, as you can tell, because the New York Times is now writing puff pieces, even without any shame at all. Like, that's just an obvious one. Jen Psaki got an additional day. Now she's going to be on MSNBC, I think on Mondays now, which could be exciting for certain people. But she had on Representative Dan Goldman. And he is saying there is still no evidence at all of any connection to Joe Biden, despite mounds of it every day coming out. Here's what he says.
So back here in Washington, Congress is returning later this month. You were the lead majority counsel in the first impeachment of Donald Trump. Kevin McCarthy has been making a lot of noise about moving forward with a process toward an impeachment inquiry of President Biden. If that were to happen, what will Congress or the White House be able to get anything done at all over the next year? I mean, this could suck up a lot of oxygen and time and effort and energy.
Right. I mean, the timing of it is interesting. We are hitting the end of the fiscal year, September 30th. The Senate has passed all 12 of their appropriations bills through committee. They are now taking them onto the floor to be done by September 30th. The House Republicans have passed 1 out of 12. There's no indication that they can get their own act in order and they can make any agreements among themselves to actually pass these bills and keep the government open. And part of the reason that they're running into trouble is that they are going back on their own agreement in the debt ceiling bill, and they're undercutting the top line amount in the appropriations bills that they agreed to. And so this is the constant and persistent dysfunction, chaos, and just complete disorganization on the part of the Republicans who cannot run the government. And instead, what they are doing is focusing on doing the bidding of Donald Trump, distracting from Donald Trump, and trying to launch a completely baseless, meritless impeachment investigation. It is one thing to actually go forward with any misconduct, but we're not talking about impeaching Hunter Biden. Hunter Biden is being dealt with by the Department of Justice. There is no evidence, none whatsoever, and I don't care how much they say otherwise. I have looked at it. There is no direct evidence that President Biden was involved in any way, shape, or form in Hunter Biden's business dealings. And they would be going forward with an impeachment inquiry based on lies.
Man, that's pretty good. Man, that's pretty good. I was waiting to see if he would have a tell. You know, we're looking at these tells. Like, he knows he's full of crap here. There's mounds of evidence. Hunter texts his Chinese counterparts, "I'm sitting here with my daddy," or else, right? Like, that's on record. We've got tens of millions of dollars in SARS and other reports. We've got photographs of Joe Biden golfing with Hunter's business partners. We've got Joe Biden at dinners. We've got Joe Biden making phone calls. We've got Devin Archer's testimony. We've got Hunter's text message saying, "I've been paying for half this family's crap for 30 years. All of it, right? All evidence. And he still can't find a bit of it, but he can say it with a straight face. Like, I wonder how many times they practice this. I wonder if his staff, they're like, "Hey, good morning. Let's work on your lies. Let's work on your lies today." Like, "Did you bring your flashcards?" He's like, "Yeah, I got my Biden one." Try it again. And watch that blink right there. I was waiting for a gulp or a blink at some point. There it is, right? You can see it. There it is. And it's right when he's kind of delivering one of those moments. Here it is.
They say otherwise. I have looked at it. There is no direct evidence that President Biden was involved in any way, shape, or form in Hunter Biden's business dealings.
There it is.
And they would be going forward with an impeachment inquiry based on lies.
Busted. All right, we got you. You're busted. You're a liar, not Republicans. The evidence is there. Keep practicing there, Dan. You'll get better at it. Keep practicing. We'll see you back here. Now, Senator Coons, he's been doing this a little bit longer, and so he's more used to covering up for the Bidens. He is somebody who is out in Delaware, and he gets asked about this too. You know, Hunter's going to be indicted again on really like meaningless charges relative to his other criminal conduct. Hunter has so much criminality, okay, that there's a whole book about it. It's called The Report on the Biden Laptop by our friends at Marco Polo, USA.org. But they charged him with a gun crime, you know, like a paperwork gun crime, because it's a red herring. It's a shiny object. Look over here. Hunter's getting prosecuted. Great. Forget all this other nefariousness. But they just say it's nothing new. Here's a senator.
Let me ask you about the latest news out of the special counsel, David Weiss, investigating the president's son. Hunter. We've learned that he plans to pursue an indictment on the gun charges before the end of the month. Here's what President Biden had to say about all this 4 months ago.
Sir, there is something personal that's affecting you. Your son, while there's no ties to you, could be charged by your Department of Justice. How will that impact your presidency?
First of all, my son's done nothing wrong. I trust him. I have faith in him.
He's said that many times. His son did nothing wrong. So let me ask you. You're close to the president. Do you have a sense? He's obviously not going to interfere. He says he's not interfering with this investigation. But when he learns that his son's going to be now indicted on this gun charge, what's his reaction?
He's sad, man. He's sad, bro.
John, there's no news here. This is the same charge that U.S. Attorney Weiss was preparing to go to a resolution here in the court in Delaware. He was deep in addiction. Hunter Biden was when he misrepresented that on a background check form. That's been publicly known for a long time now. He was late on paying his taxes twice. And in a Reuters poll last week, a majority of Americans, 2/3 of Americans, made it clear that they know the difference between Hunter Biden and his legal challenges and Donald Trump. Hunter Biden is not going to be on the election polls, is not standing for election next November. Donald Trump likely is. And
okay, Hunter might be running the White House for all we know. As far as we know, he's living there, and he has been palling around with daddy on all of his trips. But you can just see, man, it's really good spin work. Now, this guy's been around for a long time. When I press play again, look down here at the bottom. It says Biden ally Senator Coons, right? And this is funny. I mean, shout out to ABC for pointing that, making that known. Yeah, he is a Biden ally. He's just a talking point spinster senator.
The 4 different legal matters where Donald Trump's been charged with 83 counts stand in stark contrast. As the reporter who asked that question you just played recognized, there's no ties between President Biden and his conduct as president and these regrettable matters with Hunter Biden. Hunter's looking forward to resolving this, to moving forward with his life and his recovery. And I frankly admire the fact that President Biden stands by his son. But it doesn't implicate his leadership as president, and I don't believe it'll have an impact on his reelection.
But does the president believe his son is being unfairly prosecuted?
By his own DOJ?
I won't speak for him on that matter, but he is committed to staying out of this, to allowing the Department of Justice to conduct what has now been a 5-year investigation and to move forward with this matter as they should. And I think that stands in sharp contrast to his predecessor, who interfered in lots of matters at the Department of Justice. Joe Biden knows about the importance of the rule of law and of staying out of this particular matter and of having a hands-off approach to how the Department of Justice conducts its inquiries and its ongoing business. So I respect that about President Biden.
They are so full of it, my friends. It's unbelievable. He knows better. He knows that David Weiss, which was the guy who was appointed as the U.S. attorney, they held him over from the Trump administration, but he used to literally work with Beau Biden, okay? The guy who was put in charge of prosecuting the Biden family, being all go-getter, used to work with Beau. And when he went to go get permission to file in D.C. like Merrick Garland said he had, or to file in California like Merrick Garland said he had, he was rejected by Merrick Garland, Joe Biden's U.S. attorneys who were appointed at those various jurisdictions. So this dude is just lying. Like, he knows better. He knows very well that this is all corrupt, and he's just delivering talking points, and it's really gross. But they sleep at night somehow, and we have people on our side like Byron who correct the record, and he does so accordingly.
These accounts that were set up originally, the core of the tax evasion that Hunter Biden did do to the tunes of millions of dollars, the accounts that were set up were when Joe Biden was vice president of the United States. Joe Biden was in business meetings with Hunter's clients. Joe Biden was on the phone. Now we find out that there's 5,400 emails that the National Archives has had this entire time where Joe Biden is using fake names in these emails, fake email accounts, so he can communicate with business partners on the side. All the while, Joe Biden has consistently said he never knew anything about what Hunter was doing. Then they had to change the story to say he never benefited from what Hunter was doing. But there is a text message from Hunter Biden to his daughter saying that at least you don't have to pay half of your salary to me the way I have to do it to my father. This is a joke. It is public corruption. And I believe that when we have these emails, it's going to demonstrate what we all know, which is Hunter Biden and Joe Biden have been in cahoots the entire time.
Byron Donalds laying it all out there. So for some reason, he can piece it together, but guys like Senator Coons and Dan Goldman, they have a difficult time reading text messages or something, or they're just partisan hacks who are just covering up for their political allies, which of course we know. But Joe Biden is sad, and he's going to get, I think, a lot more sad when they start to realize how deep this rabbit hole goes. As Congress continues to dig, we're going to be here to cover, my friends. Thank you for joining us as we do. Thank you for subscribing and liking this video, and we'll see you back here on the next one. All right, my friends. Well, that is it for us on the day. We covered some good ground. Joe Biden is sad. Hopefully he watches a movie and has some ice cream tonight. The left insurrected Kevin McCarthy's Capitol office building. And you know, when I was typing up the description for the show today, it said insurrection is misspelled. You see that? Or it says insurrect is misspelled. You realize insurrect apparently is not a word? Insurrect is not a word. It should be, because everything's an insurrection now. Meadows also had his removal denied. He filed an immediate appeal, and Donald Trump moved to recuse Judge Chutkan because she's partisan and not fair or impartial at all. So that is it for us on the day. Let's say hello to you, my friends. See what you have to say about all of this. Very generous support coming in. I thank you all for sending it in on this lovely Monday. Grateful to be here with you and getting this all started. We had this one come in from this morning. We were talking about 9/11. Rocky Water said, who are the tenants of Building 7? Whole bunch of government people. I remember seeing it. I think CIA, a bunch of people were in there. A lot of different people. If you look it up on Wikipedia, I think it had an actual list of all the tenants. And yeah, very interesting stuff in there. No doubt. Okay, so I'm trying to get queued up. Where am I? Here on the day. Man, we have a lot of super chats today. Thank you, everybody. That was this morning. And here we are. Crash. Sorry about that, guys. Crash says, Rob, I'm not a scientist, but fuel from the full tanks could have been spewed or spilled from the aircraft. Yeah, that was a morning tip. We were asking ourselves a lot about 9/11 this morning. Certainly. And I think there's a Trump clip going around where Trump said that there may have been bombs in the building, but that could be a good response. Maybe it was just the airline fuel, right? Thanks, Crash. We got Spud says, New York has a similar policy as California. No internal combustion engines sold after 2035 and no gas stoves on new construction after 2026. Amazing. NY says, Rob, I don't agree Building 7 was demoed, but what if I stipulate the government did it because of the garbage, because of COVID? In plain sight. All right, so we'll leave that one. Bodie says, Judicial Watch sued to get footage about the Pentagon, and he posted it on Twitter. We covered that one. And we had some good comments this morning. And so this one came in from Catherine Rex today. Catherine Rex says, on a motorcycle, don't start yet. All right, we'll start it over again. Adesia's got shopping to do. Spud says, partner with the United. I think that one was yesterday. Catherine's home. We can get started. Thanks, Catherine. Glad you made it home. Shows now we can get started. Thank you, Catherine. We had this one from Chilulu Shaite. Says, hey, Rob, given what we know about Judge Cannon's legal experience, do you think she is a strong enough litigator to help defend Trump before Judge Cannon, or should she continue to serve his defense team in another capacity? Oh, I think this is a comment about Judge Cannon. Okay, this is a comment like Judge Cannon is working for the defense. I think that Judge Cannon is doing an outstanding job and she should remain as a judge. I think maybe Judge Chutkan should leave her position and joins Jack Smith's team. How about that? She should resign and just become a prosecutor with his office. She can work right next to Jay Bratt. We've got Catherine Rex says, I was at the gas station, LOL, no texting and cycling. No texting and cycling indeed. We've got Tony, hey, What's up, Tony? Thanks for bringing in 5 new membos. Blackfoot Man, Revolutionary Blister, JL, Doctor Who Eric's in the house, along with Kevin B. All invited, courtesy of Tony Hay Muckets. Tony Hay, thank you for bringing in 5 new amazing membos. Fred is here. He says, I was in New York City on 9/11, 1.4 miles from the towers. I heard the first plane, saw the second. I was 37. I still have nightmares about jumpers, but it's me. Oh, man. Brutal. Thanks, Fred, for sharing that. Hopefully you find some peace on that one, my friend, even after all these years. I'm sorry to hear that. Dolphin's here. Dolphin fan is the man. Thank you, Dolphin, bringing in Tornado Sunflower, E Artsy, Anything Artsy, Mark L, CAM, and A Bad Poet, all coming in thanks to Dolphin fan, who is the man in the house. Thank you, Dolphin. We've got Goofy for Jesus, says, with inflation, I hereby offer free gas, pulls finger. Oh, Goofy for Jesus. I think that's I know what kind of joke that is. Thanks, Goofy. We've got this one from Tony Hay. Says, I love your brother. I've been watching you for a couple of years now. You have explained the law to me. Tony Hay Munkets, member for 5. Joey? Yeah. Joey is the man. Joey is the man. And I love him too. He's a good brother. And yeah, thanks for being here, Tony Hay. For 5 months, we're over the halfway mark on the baby. We'll be getting there soon, I hope. Goofy for Jesus says, truth from Trump's trials provides appeals for J6ers. That's interesting. Yeah. So I'd be curious to see. I'd be curious to see what comes out of this trial, if much of anything. I'm wondering what defense Trump provides. Yeah, we'll see. Look, I mean, we've covered a lot of J6 stuff here, and the J6 stuff, the judges narrowly tailor it to make it mostly useful to continue the government's narrative at the expense of the truth. Voices here. What about Chutkan working at the same law firm as Hunter before Burisma? Is that not a conflict of interest? So I would also agree with that. Yeah, what was that? Like Boyes, Schiller, Flexner, one of those, I think, Voice was one of those. So I think she did work. She's also got some private practice conflicts. Now, the judge is going to take a look at it, and she's going to say, of course not. I'm not biased here. I would never be biased at all. I can set aside this and that and the other things. And my question is, yeah, it's going to be interesting to see how this all unfolds. Thank you, Voice, for sending that one in. Larry says, any conservative person could never receive a fair trial in front of this Marxist judge, including all previous trials held in her court. She certainly seems like she is of a particular disposition, and in favor of Donald Trump or anybody who's even on that side is not one side of it. Thanks, Larry. Tony Hay says, I have been watching you for a couple of years now. You've taught me about the law. At this point, we need solutions. The show is starting to remind me of an 80s soap opera. Just blanking and wait for the next episode. Well, Tony, I'm open to suggestions. If you have a good solution that can fix all of our problems, I'd love to hear it. And we'll talk about it here. We got NY says, so it's not hyperbole on my part. After 2024, Judge Chutkan deserves to be on the list to be investigated by the House of Representatives and should be impeached. And if convicted, taken off the bench. It's based on the bias that's dripping from her decisions. C. John, what's up, C. John? Bringing in 5 new membos. Thank you for doing that, C. John. Guess who's coming in? Thanks to C. John. Opposing Force, Danny M., Jace C. Clark, Verank Gaming is here, and Danny Law in the house. All welcome aboard. Thank you to C. John, bringing in new membos in the house. NY over on Locals says, Rob, he uses one of his reasoning. Since it is Georgia RICO, and under Georgia RICO, he doesn't have to be accused of a crime to be charged, just that he's part of RICO. Then throughout the whole decision, he talks about what he's accused of, so the judge contradicted himself back and forth. He then went into Hatch Act. He isn't charged with Hatch Act, as it's a federal charge. It's bogus and faulty analysis. It did feel to me like he was trying to fit it in, like he was trying to make it all work. I think the reason he brought up the Hatch Act was to say, hey, Mark, you said yourself that you can't do political things. And so he's bound by his own, he's hoisted by his own petard type of a thing. But I get your point, and I think he's trying to make it fit. And this is one of those things that's immediately appealable. We'll see what the Court of Appeals says about it. This one came out from Jeremiah in the House. He says, hey, Rob, Marco Polo delivers again. We have another Biden email alias. Oh, man, Marco Polo, those guys are amazing. If you have not already gotten yourself a copy of the If you have not gotten yourself already a copy of the report on the Biden laptop, you can certainly do that at marcopolousa.org. They're doing great work over there. Thanks for the heads up on that one. I'll have to look at that article. We got on YouTube, Pinochet's helicopter tours says, I recall that SC justices, Supreme Court justices, are assigned specific circuit courts. What determines when a lone Supreme Court judge oversees a case or appeal versus the full court? Well, so it's like, I'm trying to think of a particular example. So like, I think on this channel, I think we covered a situation in 2020 when Chief Justice Roberts fielded a request for an injunction from the Pennsylvania courts. So like, it's kind of like one-off situation. So I'm trying to think of an example that I can articulate. But there was one example where they basically, they took it to their circuit court judge, assigned judge. Then he brought it to the court. And if you want an injunction, you've got to get 4 members of the court to sign off on it. If you want the full case, you've got to get 5, or there's some rules about what cases get accepted into the Supreme Court. But it's a complicated question. I don't know all the ins and outs of it. But there's been certain situations where the judge will step in. Like we've covered it here, Clarence Thomas and others. I can't remember it right now. But it's a good question, Pinochet. We had this one coming in from SD 1985, who says, any truth that Chutkan worked at Fusion GPS? That I don't know about. I have not heard anything about that one, that she worked at Fusion. NY says, researchers were caught intertwining monies. Protesters need to be in jail without bond, just like all the January 6 people awaiting trial. We had Tony Hay says, Rob, I want you to know that I love you and I appreciate you and I love the chat. We just need to find solutions. We need to fight for America. This is serious stuff. I love you, Robert. We can't lose our country. Well, Tony, I personally think that this is a part of the solution, okay? Having conversations, staying engaged, talking through these issues, educating ourselves about the work that we do here. I think it is. Like we're building a community, awakening other people, learning what these people are doing to our lives. Like I think it may not feel like a solution, but this is a solution. I think if you go back to our founding era, read the Federalist Papers and the Anti-Federalist paper, like a whole revolution was built on letters and writings and meetings and conversations. The whole thing. It was all, that's the foundation of the whole thing. They just didn't, grab their guns and pitchforks. It took a lot of time and a lot of building. And that's what we're doing, man. So that's what I think is appropriate. And I agree with you. It is serious, but we're going to do it peacefully and slowly and methodically. And we're going to build a strong foundation and we're going to win with ideas and hearts. And we're not going to, we're not going to censor other people into joining our cause or threaten them to take this or else. We're going to win through attraction, not promotion, and we're going to be successful that way. And I'd be very cautious about the other people who are talking about other solutions that are, telling you to grab your pitchforks. Be very careful about that because there are feds everywhere. All right, Tony. We got NY says, McCarthy is third in line for the presidency. This is no joke. Liberals think based on emotion, not logic. They would jail us all if they had the chance to indict us. Jail us for our thoughts and belief in frank moments. They'll admit this, from NY. Alma Lopez became a member. What's up, Alma? Welcome aboard as a member. over on YouTube. Very nice to see you. NY says, so the senator is incorrect. In the 2000s, Biden was late. Biden's friend, daddy's campaign donor, paid his taxes. He did not pay 2014 or 2015 due to the statute of limitations. We've got Saintly Beginnings says, will you go over John Eastman's disbarment case in California? Barnes mentioned that evidence over election issues was presented. Probably not. I think other people have been commenting on that one, and it has been moving forward. I don't know what the status is. If there's anything in particular that I can, frame into what we're doing here, but other than that, probably not. I think other people have been covering it pretty well. Pinochet says, if Trump's judge worked at Boys Schiller with Hunter Biden representing Burisma, and she represented Fusion GPS, would that be a conflict of interest? So I say yes, it would be. She would say no, it wouldn't be. And it's up to her ultimately to decide on that recusal and whether she thinks she should recuse herself. And I think at this point she's already said no, or it has not crossed her mind. In other words, that issue was not a trigger for her to remove herself. Curtis is here, says, thanks, Rob. Great campfire. Love the info. Thanks, Curtis. Thanks for being here, my friend, and thanks for the nice dono on that one. Third proverb says, bank records and emails don't count as evidence, you maroons. Yeah, what do you want? To be honest with you, I don't know what else they want, actually. Do they want direct deposits? Do they want Joe Biden walking out with a big check? Maybe a big check is what they want? Like a big, 3 by whatever? Joe Biden walks out signed by Hunter or something? That's not going to happen. All right, third. Thank you for that. Pinochet, is it fair to declare J6 trials a star chamber? I don't know. Pinochet. We have this one from B-Man. Says, nothing's going to happen to the Bidens in Congress. Nothing's going to happen to the Bidens, and Congress is just wasting time. I really want to know what happened on January 6th, and Congress doesn't want to find out. I think you're right about that, and I think we've seen some issues with Kevin McCarthy. I mean, wasn't he supposed to release more footage? And he hasn't yet. I think that there was some concern about that. But I think they're pretty much settled on this. They got what they wanted out of it, and the story has been written. We've got Jameson says, publish more videos on Rumble. Right on, Jameson. So if you're interested in some Rumble videos from Jameson, certainly go check those out. Geegum is joining us, says, yay, I made the live show where the best people ever hang. Right on. Geegum, our lovely meme Smith in the house, reminding us all to hit that like button. And thank you, Geegum. Good to see you. Glad you made it. Hopefully you're having a beautiful Monday. Glad you made it here. Salty says, Building 7 had a backup generator with 20,000 gallons of fuel for the feds and police agencies. Also, there was a ton of ammo and explosives in the house, so they pulled the firefighters. That's what that was. This morning we were talking about, somebody said that they pulled it. They pulled Building 7. But what did that mean? Some people think pull it, hit it, torch the building. You could pull the firefighters. You could also pull the resources. We're losing. Pull everybody out. Interesting, Salty. Jameson says, you want the regs on judges' conduct? I don't think so, Jameson. I think I can dig those up, but thanks for the nice offer. We got Griffs over on Locals. Says, is there a recusal appeal process when she refuses recusal? If she is recused, what happens to any bad decisions she has made so far? Good questions, Griff. Yeah, good questions. I'm not sure. If I was Donald Trump's defense, I would say I want a motion to reconsider the trial date, for example, right? She scheduled a March trial date. That kind of feels insane. Maybe you'd ask for that again. A motion to reconsider, I think, would come for at least the bad decisions, not necessarily every decision, but the ones that you thought were prejudicial against you, I think would be appropriate. MAGA Hat Stays is sharing a dono, a couple images. What is this one? Thank you, MAGA Hat, for the tips, sharing somebody about somebody who died, something about Wisconsin, something about the FISA courts, all different images that came in. Thank you for those, MAGA Hat. We got Jameson says the Rumble channel is The Blind Lawyer Explains, if you want to go check that out. And Rocky Waters in the house says, Rob, good stuff as always, appreciated. My only complaint with your show, and it only covers about 3 to 4 hours of my work hours. Ugh. Luckily, this week, I have the Paxton trial to fill in the gaps, but I worry about after that trial ends. Any chance you could do like, an 8-hour show starting at 8 a.m. Pacific time? We've done that before. I mean, we've done, what was some of our longest ones? I think we did some trials here. Was it the Kerry Lake trial? Very long one. And those are long days. But watch it on ultra low speed, Rocky. Watch it at like 0.25 speed, and it'll get you there. It'll get you through the day. All right, MAGA Hat says, Congress has some process for accessing to some bit, not all of the footage starting this week. I did see that. Yeah, there's like a form process, but I thought it was very restricted. Like you can't take the footage out. You can only take notice of the footage. You can only talk about it, but not actually take the footage. I was reading about it and I was like, this doesn't sound appropriate at all. All right, and thank you for that, MAGA Hat. And Salty says, I am ex-Air Force. Every large aircraft is a flying gas can with 100 to 300,000 pounds of fuel on board at takeoff. 100 to 300,000 pounds of fuel. It's a lot. DC-8 to KC-10. That's a great comment. Thank you for that, Salty. I guess my next question for you would be, can you fly a plane into the Pentagon like that? That was our other question this morning. Feels like if you're coming in a little too high, you miss it, you shoot over top. If you're coming in a little too low, you crash into the ground. And so it's like, that's not a huge building, so it's like an amazing shot. We were talking about that this morning and watching some other footage over there. Yeah, I don't know. Good stuff. Okay, we got MAGA Hat says, keep the faith, hold the line, and own the libs. Keep the faith, hold the line, and own the libs. No doubt about that. All right, Posh Hawk, welcome over on Locals, says, if we end up in 15-minute cities, I hope I end up with all of you. Well, that's, it's kind of the plan, is to stay connected in case stuff happens. We got to stick together, man. We got to stick together because the world is going to get crazier and crazier by the day. And we got to stay together, stay connected, and support each other. All right. Who is over on the X? We got people watching. 5 viewers over on the X. We got Danny McWilliams. Says, Rob, I don't think you get it. This is a fight, and due process is the prize. Tell me what happens to lawyers if we lose due process. Lawyer fight in court. Judge trusts lawyer in jails. There's nothing funny about this case. Fred says, Chutkan didn't work for Fusion. She defended them in court and had to recuse. Kash Patel was involved. This one is little Johnny. Johnny said this, says, if Chutkan is allowed to preside over our trial, I will be 100% done with our legal system. From Fred Pedamonte in the house. Trans Roof Korean says, I feel like one of these days you should show up on Recuse's shows to discuss all this that you've been covering. Too late or something? Yeah, man, I would love to talk to Recuse again. Yeah, I love chatting with Recuse. It's been a long time, and we've been meaning to do something. I actually sent him a message like months ago, and then I just got busy, and it is a little late. Yeah, it is a little late. He's like a 9 or 9:30 guy. I'm usually like drooling on myself by about 9:30, so it's harder for me. But certainly, like it'll be worth it. Maybe on a weekend or something, or on a Friday night, we can do something. That would be fun. I love Recuse, and I listen to his stuff too. Angel's here, says, I'll be there in a minute. I'm 14 minutes late. Glass Onion is here. Size in the house. Randy Egram says, I love your informative shows. You're able to point out the depth of the deceptive corruption. Good to have someone to explain things. Thank you, Randy. Very nice comment. The Mad Tweeter says, how the heck did the recusal of Meadows fail? He literally set up phone calls, went to observe a facility. This system is a disaster. From the Mad Tweeter, no doubt about it. And Supersonic Station says, mostly peaceful insurrectionists insurrect McCarthy's office. Bernice, what's up, Bernice? Says, your community is awesome. I agree. We got the best community. Says, I'm watching you on YouTube and my TV, watching on Twitter on my phone. Thank you for informing me, but making me laugh. Your community is awesome. And Johan Wallace is also over there. Johan Wallace. Hey, look what I found. Shout out to the Wallaces. Shout out to Bernice and Johan Wallace bumping into each other over on the X. How funny is that? We got the best community, man. We have the best community. And thank you, everybody, for the very generous donos. For sending those in. I appreciate all of them and everything you do to keep us busy here and on track. And so, my friends, let us leave it there. We are going over to our members only after party at watchingthewatchers.locals.com. We'd love to see you join us. We do members only streams in the morning. We do Saturday shows. We'd love it if you checked it out, watchingthewatchers.locals.com. We also have our members, our new website, robertgovea.com. And if you click it, hopefully it loads. While it's loading, we've got this from Salty Sarge. It says the Pentagon was taken out by a rocket, especially accounting. What the heck is going on with the website? Is my internet? It says the Pentagon was taken out by rocket, especially the accounting office, and says, never let a crisis go to waste, especially the accounting office with a ground rocket. Never let a crisis go to waste. So that's from Salty Sarge. And thank you, everybody, for those very generous donos in the house. We're grateful for all of your support here on the house. And so we are going over to watchingthewatchers.locals.com for our after party. We'd love to see you there. Don't forget to check out our friends at fieldofgreens.com, where you can save 15% off with code Robert when you check out. Big thanks to our friends who are modding down the fort for us, our friends Vientikis Prime, K Beans in the house, Just Cause, Playin' Hooky, Ronnie Cole, our friend Zulu, GeoStars, Zach Nichols, John Allen, Janek 909, Dog Digger, Donut Mind Me, and John McGarvey all in the house, along with our meme smiths, Sleepy Dog Lee, Geegum Geegum, and Nathan N810, our friends who are meme smithing the fort down for us. Thank you for everybody who joined us and made the show possible, but we are done for the day. We're going over to watchingthewatchers.locals.com. We'd love to see you there. But if we don't, that's okay, because tomorrow we will be back here to do it all again, and I hope to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.